Hi guys! Welcome back to my channel. So for today's video, we are going to talk about Article 20 of the RPC.
So before you watch this video, guys, I hope you watch my previous video about Article 19 accessories because this is a relevant related video to Article 19 which talks about accessories.
So Article 20, accessories who are exempt from criminal liability. So the penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees, with the single exception of accessories falling within the provisions of paragraph 1 of the next preceding article.
So, ground for exemption. So, etong Article 20, guys, it talks about the exemption sa criminal liability ng accessories.
So, grounds for exemption. So, the exemption provided in this article is based on the ties of blood or meaning families. Ties of blood or, families mo. And the preservation of the cleanliness of one's name which compels one to conceal crimes committed by relatives so near as those mentioned in this article. So the principles related to accessories exempt the criminal liability. An accessory is exempt from criminal liability when the principal.
So exempted yung accessory sa criminal liability niya kung ang principal is related niya by blood ties, if it is his spouse or blood ties, or family niya, related niya for family niya. For example, if it is his spouse, descendants, ascendants, and legitimate, natural, or adopted brothers or sisters, or relative by affinity within the same degree.
So even if only two of the principals guilty of murder are the brothers of the accessories and the others are not related to him, such accessories is exempt from criminal liability. It appeared that sometime after the crime was committed, the accused accessory accompanied with some other accused to the place where the bodies of the victims were concealed on the night of the murder and helped them to remove and bury these bodies at another and more remote spot. This is cited in the case of U.S. versus Abansado.
So even though tinulungan mo yung mga principals ng crime and not all of those principal are related to you, or even dalawa lang sa tao yun yung relative mo which is your brother, you are still exempted of such crime.
So, relationship by affinity between surviving spouse and blood relatives of the deceased spouse survive even after the death of the deceased spouse. So the relationship of affinity created between the surviving spouse and the blood relatives of the deceased spouse survives the death of either party of the marriage which created the affinity. The same principle applies to justifying circumstances of defense of one's relative, which is cited in Article 11, Paragraph 2 of RPC, the mitigating circumstance of immediate vindication of grave offense committed against one's relative under Article 13, Paragraph 5 of the same code, and the absolutory cause of relationship in favor accessory under Article 20, also the same code. So here, nephew and niece are not included among such relatives. So a nephew who had witnessed the killing by his uncle of the deceased help in burying the dead body. Is the nephew criminally liable as an accessories? The answer is yes, because the relationship of uncle and nephew is not included under Article 20. So in the case of U.S. versus Incerto, it was held that the relationship between uncle and niece does not come within any of the degrees of relationship of spouse or ascendant, descendant, legitimate, natural, or adopted brother or sisters or relative of an affinity in the same degrees.
So, hindi included yung niece at nephew sa mga exemption kasi hindi siya included dun sa exempted na state under Article 20.
So, accessory is not exempt from criminal liability even if the principal is related to him. If such accessory profited by the effects of the crime or assisted the offender to profit the effects of the crime. So here, sa last part ng Article 20, it says that with the single exception of accessories falling within the provisions of paragraph 1 of the next preceding article. The preceding article which refer here is Article 19. And I already have the video about that. I will just write it down in the description below. So the paragraph 1 of Article 19 covers accessories who take part subsequent the commission of the crime in any of the following manners. Number 1, by profiting themselves of the effect of the crime and by assisting the offender to profit the effects of the crime. So if the accessories has performed any of those acts, he is liable even if the principal is spouse, ascendants, descendants, brother or sisters, or father-in-law or son-in-law or brothers-in-law, because such acts are prompted not by affection but by desistible greed.
So here, hindi kasali sa exemption kapag even though related ka pa through blood ties, but yung crime na nakumit na, or but yung accessories na nakumit mo is under paragraph 1, under article 19, hindi siya kasali, which is yung profiting or assisting the offender to profit by the effects of the crime. Hindi siya kasali for the reason na yung pagtulong mo is not prompted by the affection, or hindi cause, yung pagtulong mo is hindi cause dahil relative kayo kaya mo siya tinulungan, but it is caused by greed na gusto mo ring makaprofit, or gusto mo yung brother mo or yung relative mo is makaprofit for such crime that he committed. So yun yon.
So the daughter stole the earrings and the mother pawned them as a pledge for her debt. The mother is an accessory, for although he had no part in stealing the earrings, she took steps to obtain gain and profit the same effects of the crime. So the relationship does not exempt her from liability because she assisted in obtaining profit from the theft. This is cited in the case of U.S. versus Joda. So only accessories under paragraph 2 and 3 of Article 19 are exempt from criminal liability if they are related to the principal. So a son who helps his father bury a body of a person whom the latter has murdered in order to prevent its discovery, a grandson who, having knowledge of the commission of the robbery by his grandfather, conceals or destroys the body of the crime or the effects of instrument thereof in order to prevent its discovery, and the person who harbors, conceals, or assists in the escape of his brother who committed treason do not incur any liability, because the acts of accessories in those cases are covered under paragraphs 2 and 3 of Article 19. Not one of them falls under paragraph 1 of the Article 19, because none of those accessories profits or assists the offender to profit by the effect of the crime.
So here, yung exempted lang na acts ng accessories dito is yung acts under paragraph 2 and paragraph 3 ng Article 19. So kapag paragraph 1 yung ginawa ng accessory, is liable pa rin siya maging accessory even though they are related to each other by the principal.
So, the question is, does the concealing of the effects of the crime not to prevent its discovery but to obtain gain fall under paragraph 2 of Article 19? So, excuse me. So, paragraph 2 of Article 19 requires that the purpose of the concealment is to prevent the discovery of the crime. On the other hand, paragraph 1 naman, it says that profiting themselves by the effects of the crime. So, does paragraph 1 mean that the accessory should actually profit from the effects of the crime? That seems to be the meaning. But suppose the husband conceals the property stolen by his wife in order to profit it later. Is he liable as an accessory? It would seem that he may be held liable. Excuse me. It would be seem that he may be held liable as accessory because his said act is prompted not by affection but by detestable greed. In that case, his purpose in concealing the stolen property is not to prevent the discovery of the crime. But suppose A, who committed parricide by killing his wife, went to his adopted brother to hide in the latter's house, and his adopted brother harbored and concealed A because he gave his adopted brother 1,000. Is the adopted brother an accessory or he is criminally liable?
So kapag si A, napatay niya wife na, then pumunta siya dun sa bahay ng kanyang adopted brother para magtago, tapos binigyan niya yung adopted brother niya ng 1,000 pesos. So, question here is the adopted brother is accessory or not?
So, the ruling is that he is an accessory because knowing that A committed parricide, he harbored and concealed him, but he is not criminally liable because he did not profit to the effects of the crime. So the 1,000 received by him from A was not the effect of the crime of the parricide.
So, di ba? So, hindi siya magiging liable kasi yung 1,000 na binigay ng kanyang stepbrothers, hindi naman yung effect ng crime. So, meaning hindi siya nag-profit dun sa crime na ginawa niya. So, still, he will not be liable. Liable.
The question here is liability of an public officer when related to the principal. So, is the public officer who with evident abuse of his office furnished the means to escape to his brother who had committed murder criminally liable accessory? Such public officer does not incur any criminal liability because ties of bloods or relationship constitutes a more powerful incentive than a call of duty.
So, even though public officer ka, tapos tinulungan mo yung, ginamit mo yung power mo as a public officer and you abuse it para makataka sa murder yung brother mo, is you will not be liable because yung ties or blood or relationship mo it is more powerful than the duty mo as a public officer.
Furthermore, Article 20 does not grant the benefits of exemption only to accessories who profited or helped the offender to profit by the effects of the crime. This is the only case where the accessories who is related to the offender incurs criminal liability.
So, that ends my video. So again, Article 20 talks about exemption sa sa criminal liability ng accessory. So ito yung exempted dito is yung mga family niya or blood relative or ties or ties of blood. So ito yon. But ang exemption niya, exemption dito is hindi exempted even though relative pa kayo if yung accessory na na-commit nyo is paragraph 1 of Article 19 kasi or profiting or assisting to profit the principal kasi yung ginawa mo is hindi naman through affection but through greed na, di ba? Kasi you want to profit. So ganun yon.
So, this ends my video. I hope you learned something from this video and I highly recommend to watch my previous video, Article 19 about accomplice, so that you would understand this video. So, again, thank you so much for watching. Don't forget to subscribe to my channel. Bye-bye!